Hello, everyone, and welcome to Democracy in 5 Minutes. I'm your host, Paul Manna, here in Williamsburg, Virginia, where I'm a professor of government and public policy at William & Mary. In last week's episode, we explored how the courts can provide a check on presidents when presidents fail to faithfully execute the laws. An obvious question about the courts that follows from that idea is, what if judges rule against the president and the president just ignores them? Is there anything the courts can do? That's a hugely important question given recent statements and actions from the Trump administration that have resisted court orders. We've seen a lot of this in immigration policy especially. The quick answer to that question is that there are some things courts can do, but the effects are likely to be limited when a president is committed to pursuing actions that violate the law and disobey court rulings. Let's jump in and begin exploring why that's the case. I want to start by laying out what courts can do if a presidential administration defies a court order. There are a few specific things. One is that judges can reiterate their orders and make them more specific. In extreme cases, they can issue what's called a writ of mandamus, which compels a government official to perform a very specific act. For example, if the court found that a federal official was illegally withholding funds that states were obligated to receive due to a federal funding formula that Congress had written, a writ of mandamus could include language that orders the official to disperse those funds, even if the president said not to. That sort of prescriptive instruction fails. If it fails, judges can consider punishing executive branch officials themselves. For example, they can sanction executive branch attorneys. This can happen when attorneys violate their oaths to be faithful participants in judicial proceedings. An example could be if lawyers take frivolous actions or make arguments that they know to be inconsistent with the law or the Constitution. These penalties can include fines or a judge suspending an attorney from further participating in a case, and even more severe professional consequences for the attorney could follow, including disbarment that prevents them from practicing law at all. Judges can also hold executive branch officials, not just the lawyers arguing the cases, in contempt. This power flows from the Judiciary Act of 1789, the original law that set up the federal court system. Contempt is a finding that a party has not complied with a court's order. And the penalties for this can include fines for the relevant individuals, including government agencies, and even jail time, although admittedly that is a very rare consequence. Now, despite these potential actions judges can take, there are important limits on their power. The key problem is that the federal courts lack their own personnel to prosecute or pursue sanctions against executive branch officials that violate court decisions. Instead, judges rely on two sets of officials in the executive branch itself to enforce their orders. The U.S. Marshals Service is one. U.S. Marshals work for the U.S. Department of Justice, but one of their main jobs is to help the courts, even though they have many jobs. Laws that created the Marshals Service state that, quote, their primary role and mission is to obey, execute, and enforce all orders of the United States District Courts, the United States Courts of Appeals, the Court of International Trade, and the United States Tax Court as provided by law. The second category of officials that judges rely upon are U.S. attorneys, who also are employees of the U.S. Department of Justice. When a federal judge holds someone in contempt, for example, they themselves don't prosecute these cases. Instead, they call upon U.S. attorneys to make those arguments and move those cases forward. This reliance on Justice Department officials places huge limits on the federal courts as they try to hold executive branch officials accountable for their conduct. In President Trump's case, if his Attorney General Pam Bondi doesn't want to instruct the U.S. Marshals or U.S. attorneys to help the courts enforce their orders, then there really is very little that the courts can do. That reality has many people worried, given that President Trump has required his top officials to be personally loyal to him, and Bondi has been one of his most loyal appointees. This behavior has prompted big concerns even from former Trump administration officials. Here's what Ty Cobb, who was a former White House attorney to Trump during his first term, has said. Quote, never in history has the Department of Justice broken so defiantly from respecting, as it's obligated to do, the decisions of federal courts. This is a war that Trump and Bondi are waging against the rule of law. So we can see that these actions are really unprecedented given the long sweep of history. So what can you do with this information? Here's how I would suggest you use it to shape your thinking and your listening in the coming weeks and months. First, keep your eyes on the language that the courts use in their rulings. In recent weeks, especially across lots of federal courtrooms hearing challenges to Trump's actions, judges have issued harsher and harsher assessments. That language has come from judges appointed by presidents of both major parties, including some of Trump's own appointees. Try to get past what TV pundits are saying about these cases and look directly at the concerns the judges themselves are expressing. All of their rulings are public and easy to find online. Second, pay attention to whether any of that language from judges starts to break through with Congress and whether it motivates action from the legislative branch. That's important because opposition to Trump administration actions that violate court orders will not come from within the executive branch itself. Officials in the White House or federal agencies openly defying Trump will simply be fired and replaced with others who will do the president's bidding. So any pressure, especially political pressure to get the president to obey the courts, will have to come from Congress or the people. It's on that point that I'd like to wrap up today's episode. Thanks very much for tuning in, and I look forward to sharing more thoughts with you next week. Take good care, folks, and I'll see you then. Bye-bye.